Um, on behalf of the Mexico Center at Lilas Benson, I want to welcome all of you to our conference on Mexico's energy sector at the Crossroads. We have been toying with the idea of a similar presentation for some time, and the events around the energy sector and the new electricity law and so on really quickened the pace here, and so we're really delighted to be having this conversation with you about a topic that seems very timely. And I'm Ricardo Ainsley. I'm the director of the Mexico Center, Lilas Benson Mexico Center. And by the way, let me just say that one of our benefactors, Teresa Long, just passed away. She's been very generous with the university, very generous with Lilas Benson, and is a person of great generosity in her spirit as well. So I want to acknowledge her passing here in the introduction. But the Mexico Center does a lot of work creating linkages between the university and Mexico, Mexican institutions, Mexican scholars. So we're really excited to have the opportunity to host this program. I will be introducing José María Lujambio, who's generously agreed to be our moderator for today. And José María will introduce our panelists momentarily. José María Lujambio is a law graduate from the ITAM and presently leads the energy practice of the law firm Cacheaux, Cavazos, and Newton. His work has included regulatory support for power generation projects, negotiation of energy supply contracts, and advice in hydrocarbons, midstream and downstream regulation. From 2009 to 2012, he was the general legal counsel for the Mexican Energy Regulatory Commission and worked on implementing the 2008 reforms on gas and renewables. He was also, between 2005 and 2009, the attorney at the Legal Counsel's Office of Mexico's president. So thank you, José María, for participating. And I want to thank all of our panelists who he's about to introduce for their generosity of their time and their intellect and experience in sharing their observations. José María?
Thank you very much, Ricardo, for the introduction and of course for the generous invitation to participate in this panel. I want to thank, of course, the Mexico Center at Lilas Benson and my alma mater, the University of Texas, which I am very glad to come back to it, at least on a virtual basis today. So I would like to introduce our distinguished panelists. First, it's going to be a quick introduction, and then we're going to start with a very dynamic conversation. I will start in strictly alphabetical order. So in terms of last names, so Aldo Flores-Quiroga is our first panelist. He has a PhD in political science from UCLA and a BA in economics from the University of Nuevo León. He's former Deputy Secretary of Energy for Hydrocarbons at Mexico's Department of Energy from 2000.
You've gone, José María, you've gone mute.
Yes, sorry.
Yeah, okay.
Aldo led a team of 180 government officials to implement the historic opening of Mexico's hydrocarbons sector. Dr. Quiroga was also Secretary General of the International Energy Forum from 2012 to 17, Assistant Secretary for International Affairs at Mexico's Department of Energy, and Assistant Secretary for Bilateral Economic Relations at the Department of Foreign Affairs. He has represented Mexico in multiple international organizations, and he has taught courses in the Claremont Graduate University in California. So Aldo, thank you very much for accepting to participate here with us. He's of course, well, I forgot to mention that he's a visiting professor at the LBJ Public Affairs School at UT Austin. So thank you, Aldo. Also, we have Miriam Grunstein. Hello, Miriam. Good to see you again. Miriam Grunstein is a Chief Energy Counsel at Brilliant Energy Consulting and a non-resident scholar at the Center for the United States and Mexico at the Baker Institute in Rice University. Grunstein has practiced energy law in the Mexico City offices of several international law firms and represented energy companies in a variety of transactions. Grunstein holds a bachelor's degree in Latin American Studies from the University of New Mexico, a law degree with summa cum laude from the ITAM, and a doctorate, also summa cum laude, from New York University in the language and literature of Spain and Portugal. So it's a pleasure to have you here, Miriam, and thank you very much for accepting to participate today. Also, we have Dr. David Spence. I have the honor to have been his student when I was in my LLM here in UT Austin. Dr. David Spence is a Baker Botts Chair in Law at the University of Texas School of Law and Professor of Business, Government, and Society at the McCombs School of Business. Professor Spence is co-author of the leading energy law casebook, Energy, Economics, and the Environment. He has published numerous scholarly articles on subjects relating to energy policy, regulation, and regulatory processes. He addresses particularly environmental regulation of the oil and gas industry and the electric utility industry. Dr. Spence has a PhD in political science from Duke University and a JD from the University of North Carolina. So Professor Spence, David, good to have you here. Thank you very much for accepting. And last but not least, certainly we have Pablo Sarate. Pablo Sarate is the Managing Director in the Strategic Communications segment at FTI Consulting in Mexico City. He's the co-head of the segment's team in Mexico, focusing on public affairs, advocacy, and corporate reputation. Pablo has provided advice to and managed corporate and issue-based campaigns for a broad range of clients in the energy industry and others. Mr. Zárate served as advisor and lead speechwriter for the Secretary of Energy in Mexico and as an advisor to the Undersecretary for Energy Planning. Mr. Zárate holds an MA from the School of Media and Public Affairs at the George Washington University and a BA in Economics from Mexico's ITAM, as well as a BA in Political Science from Mexico's ITAM. So thank you very much, Pablo, for being here with us today. And for the benefit of the audience, which we guess is a pretty diverse audience, I would like to start asking Miriam, the lawyer here, what are the contents of this reform, Miriam? And please set us in the context of the Mexican energy sector. What has happened in terms of the energy reforms in the past 30 years, and what are we living today? In a nutshell, 30 years in a nutshell. Or two nutshells. You have your mic.
You're on mute, Miriam.
Okay, great. So did you say 3 or 30? Because we need the rest of the session to go through the 30, but let me put it in a nutshell. What has happened, the most recent and most relevant events. 2013 and 14, we had the big energy reform in which the hydrocarbon sector and the electricity sector were liberalized. Basically, all throughout the hydrocarbon value change, things open, people could partake in from E&P, from the well to the wheel, basically, you know, exploration and production through the the sale of fuel products and service stations. So everything became liberalized. And in the electricity sector, there was also a massive liberalization. And the only thing that remained a state monopoly was transmission, distribution, and the planning of the electric sector. So that's the big context. From the change of government, which Aldo Flores-Quiroga, if I may quote him when he was leaving office, said, it wasn't a change of government, it was a change of regime. And now we are really feeling the intensity and the depth and scope of this change of regime, more so in the past few months when we had the biggest and the most profound legislative change. Basically, since the government came into office, it had been forewarning those who favor markets and the companies that things were going to change. But they hadn't had the political will to do so. So they began to change things basically in the electricity sector, in the power sector, rather than the hydrocarbon sector, which we haven't felt such changes, in which we haven't felt those changes. But we had a lot of warnings, basically in the presidential morning press conference when he would speak ill of renewable energies, and he said, oh, those horrible fans in the hills, meaning about the wind power generators, and that renewable energies were too expensive, they were too costly. And basically they were sort of very visceral, very emotional comments about renewable power generators. Then he went on and he spoke about how cheap transmission was for renewable energy generators. So all the ill will seemed to be channeled towards renewable energy. And then he issued this very strange agreement, which contains some form of public policy that forbid intermittent power generation facilities from interconnecting into the grid. Because as we are in a COVID crisis, he had reliability issues with these power generators. So the agreement was issued without following proper administrative procedure, and constitutional challenges began to downpour from NGOs, from private parties, and basically that agreement is frozen. So the president's animosity towards the private sector increased. You could feel it because he's a very emotional man. So you could see him getting very angry. And he said, well, you don't like my administrative act, I'm going to change the law. And it's a form of very scary forewarning, because he's been escalating. You don't like my administrative measure, I'm going to change the law. You don't like my law, I'm going to change the Constitution. And next thing, he's going to change the Bible, because there's nowhere else to go. But he's been escalating things gradually in a very scary way. At least for us who like markets, it's scary. For those who don't, I think it's good news. So it changed the law, the electric industry law, in some few major points. I want to be brief so my colleagues can speak, because I don't like to monopolize the microphone. Basically, he favors CFE as a seller of energy for CFE. And I think that's the crux of the reform. He's not eliminating private, but he's relegating, he's pushing it to the back burner. So, and number two, although renewable energies are not eliminated from the scope of the law, they are pushed back, and it coincides with the fact that private investors and private companies are the ones who generate renewable electricity. And he has announced that he's going to enter into these physical power generation purchase contracts, which are not those who have entered into with CFE and the private parties. And also, not in the body of the law, but in the motive section of the law, he has established some form of priority purchases, which I don't know how he's going to implement, which is first is hydroelectric power sources, CFE itself. And I think the idea behind that is giving Tabasco, which is his home state, the possibility to be the primary supplier of electricity generation for CFE. Then come other CFE power generation sources, then renewable, and then other private hydrocarbon source generation sources. So, and also in the last part of the law, which are called transitory provisions, which are not really transitory as they are, because transitory articles in Mexican law mean the steps that will be taken to implement the law. And these are not timeframes for the interpretation of the law. They are provisions that establish rights and obligations. And he said he's going to review the contracts which may be deemed to have been awarded illegally. And this concentrates very much in the co-op facilities, the self-use facilities that actually are important in Mexico because they have allowed industry to purchase their own energy as partners of these co-ops and to have lower rates in peak hours. And also, and he also has, well, no, the law, not the president, but the law states that he high. So in my view, those two aspects are the scariest ones: the review of the contracts and the possible revocation or renegotiations of the tariff rates set forth therein. And that would be, in a nutshell, what has happened. I hope I wasn't confusing or boring.
No. On the contrary, Miriam, you really did a great job summarizing the history and the contents of this new law. So I would like to move with Aldo and ask you, Aldo. So Miriam already kind of mentioned a few kind of policy reasons behind these reforms to the electricity industry law in Mexico. But would you please elaborate on those policy reasons? And also, do you think it is fair to call these reforms the fuel oil law, la ley combustóleo, as it has been called in the media, and not only in media outlets, but in social media? And like finally, a quick question related: how is it that the supposedly left-leaning government seems to be too pro-hydrocarbons in 2021? This is something that is always strange for the U.S. audience.
Wow, what a set of questions. And I was thinking of Miriam monopolizing the conversation, and she likes competition. Let's see if I can compete with let me see if I can frame this a little bit differently. I mean, it is the case that the government has said that part of the perspective of, as they call it, recuperating sovereignty means that the two national energy companies must have a stronger, more important role, as they have had historically in Mexico's energy industry. So part of what informs this reform is this view that this is something that has to be basically non-negotiable, that state-owned companies are at the core of what energy should be about in Mexico. A broader question for me has to do with precisely what Miriam has been saying about competition and how to introduce competition in Mexico's electricity sector. The model that we in Mexico have been seeing as the option, adopted, is one in which CFE, the national utility, the power company, has been the key sponsor of many of the private projects, at least to date. And it does mean, it does raise some questions about how to get to a competition where the state is not, or the state-owned company is not the main source or underwriter or supporter of long-term investment. We have already seen a successful model in Mexico of private generation to private consumption. But that has not been the key source of action necessarily during the first few years of the implementation of this reform. So a valid question is, what should CFE, what should its role should be in this new reality? So this leads me to two last points. An alternative view would be that CFE is the core of a green industrial policy, in which case the idea that CFE is this sponsor of the entrance of new generators that are more efficient makes sense, but also part of a broader strategy of promoting manufacturing and other aspects of the other links in the value chain that are associated to the green energy sector. The other thing that we must bear in mind is that these reforms take time and they are non-linear. Mexico has been seeing 3 years of a reform process that in many other countries have taken 20 years, 20 odd years. And they don't get cleanly from stage 1 to stage whatever. They go, there's progress and they go back, then they go again forward. And we don't know exactly where we are. So as a summary, I think it is, there's very interesting questions out there opened, but let me but I will definitely emphasize and agree with Miriam that the way forward has to be competition. I think there's different ways of structuring competition, and there's a valid discussion out there. But if we want to have the electricity sector and the national power company that in Mexico that happens to be, that is more efficient, that is more responsive to consumer needs, that is better able to support national development goals, we need competition without a doubt.
Thank you very much, Aldo. I would like to ask Pablo now to elaborate in some analogy that you used recently in an article that you wrote in El Economista, under which Mexico's federal government looks like Willy Coyote, no? This Warner Brothers character in his unsuccessful efforts to halt competition to CFE and Pemex. And also, how do you explain that President López Obrador is willing to even attack the independence of the judiciary pursuing this particular project? Why is it so important? Why is it the policy priority of President López Obrador?
Well, I think it's important to say at the outset that we saw a shift in Mexico very quickly from what seemed constructive nationalism to destructive nationalism, right? What I mean by that is early on in the government, it seemed that it was about building this mega project and that the focus of energy policy and infrastructure policy was going to be based around that. There was also going to be a focus on making Pemex great again and reaching 3 million barrels per day by the end of the administration. This very, very ambitious goals. And it's very clear now, Chema, that the government is not going to be able to reach those goals. And it has shifted from continuing to have those aspirations to trying to destroy everything that competes with Pemex and CFE. And as Miriam said, we are seeing that much more clearly in the power sector, where there has been a very aggressive regulatory campaign to dismantle the rights of companies and to dismantle the rights of Mexican citizens in terms of access to clean air and really environmental rights. So the reason why I brought coyote metaphor is it's very clear that we now have a government that is proactively thinking, how can I hurt private generators in the country? How can I catch them this time, right? How can I intensify my campaign, and how do I position that to the public? And if you see from the outset of the saga, which was around the clean energy certificates issue, to the moment that we've reached, it's a very intense escalation, very much like you would expect in the cartoon. The first time he tries to do it with his bare hands, right? He goes out and says the clean energy certificates are wrong because CFE is not getting enough of those. But then you start to see a lot more complexity behind the misleading strategies that the government has brought to bear. And you start to see escalation in terms of the power of the weapons that it's bringing to bear. So it's not only regulation, as Miriam said, then we're talking about legal changes. And if that fails, then it's going to be a constitutional change, because the coyote never gives up. Now, the other reason why I think the metaphor works is we need to acknowledge that the coyote is incredibly popular. You are seeing someone that's trying to hunt and kill the roadrunner, right? Which does nothing wrong, by the way, in the cartoon. But still, we like the coyote. And I think that one of the reasons why we like the coyote is because he never gets away with it. He never gets to kill the roadrunner, and we never get to see that part, right? We never get to see him as the roadrunner killer that he is. And hence, it's all kind of fun and games. And in a way, it's all politics. And that's the part that really concerns me. These policies are about destroying private participation in the country in a way that violates the Constitution and the broader Mexican legal framework, including international treaties. If the president gets away with what he wants, and if the courts had not intervened, we would have seen massive destruction. The reason why it's still not a tragedy is because the courts have intervened. The reason why the coyote is a cartoon and it's not a tragedy is because he hasn't been able to kill the roadrunner. So I think it's important to keep that in mind and say the president continues to be popular despite all his attacks, not because of his attacks to the private sector, despite his attacks to the private sector, because we have not yet experienced the level of destruction that this would bring to bear into the Mexican economy.
Very interesting and I think very adequate analogy, Pablo. I would like to move with David Spence. As you might know, David Spence is one of the most important experts in studying restructuring, liberalization, and or deregulation efforts in multiple electricity markets in the past decades. So David, I would like to ask you, what are your first thoughts when you see all this happening in the market, in the Mexico market, which is just south of Texas, just across the US border? Aldo already was mentioning that these liberalization processes are not necessarily straightforward, but there are steps forward and steps back, and that's normal. But have you seen something similar in other markets, like as the things that we are seeing in Mexico?
First of all, thank you for having me, Jose, Maria, and I'm happy to be part of this conversation. As an American, I'm sort of looking at this from the outside, and I'm happy to give you my reaction. Let me answer your second question first. Have I seen anything like this before? Not precisely, but if you remember the early days of the Trump administration, there were a number of concerted efforts to privilege fossil fuels at the expense of renewables. And Miriam talked about the sort of emotional negative reaction of the president to renewables. Donald Trump has a similar emotional reaction to wind. Wind farms messed up the view from his golf course in Scotland, and ever since then, he's not been very favorably disposed to offshore wind, and he bottled up offshore wind applications in the North Atlantic. So presidents in other places sometimes intervene in energy markets in ways that impose friction where it really ought not to be. So that's sort of new. And in terms of two steps forward, one step back, the process of growing and maturing free electricity markets in the United States has certainly seen its setbacks, not least of which happened here in Texas last month. And 20 years ago in California, we've had some pretty big breakdowns in the operation of sort of pricing models in electricity markets. So I think that's not unprecedented either. But there are some elements of what's happening in Mexico that are quite, unusual looking to people who are familiar with the American energy context. The first is this notion that wind and solar are somehow more expensive and undesirable. That just doesn't really fly here. All of the professionally published levelized cost of energy estimates of all the different types of electric generation show over and over that wind and solar are now the cheapest on a levelized cost basis, so that when you interfere in the market in ways that disadvantage wind and solar, the way the Mexican president has, including changing the dispatch order, normally in sort of economic dispatch of power plants, you would dispatch the wind and solar farms first because there's zero marginal cost, and that brings down spot prices for electricity. And so when you push them further down in the dispatch order, you're making electricity more expensive for those who have to pay for it. People generally like clean power; they're favorably disposed toward it. So you would think that this would be an unpopular intervention in the market based on both the fact that you're making power more expensive and you're getting rid of, or you're not getting rid of, but you're reducing the use of a really popular source of energy. And of course, the long-term effects of all that and of interfering unilaterally in these contracts or amending them unilaterally is to reduce the willingness of investors to invest in these kind of projects in the future, which is a negative impact of this sort of thing. More generally, my reaction is that if there's a different view in Mexico, or there's a stronger view in Mexico in favor of government provision of energy services historically, that isn't really nearly as strong in the United States. We do have some public sector actors that provide electricity. I live in the jurisdiction of the Austin Municipal Utility, and there are some federal power agencies in the United States, but the vast majority of generation is owned by private companies, and the vast majority of customers are served by private companies, and Americans have kind of gotten used to that for the most part. We don't have that sort of history of exploitation by foreign energy barons. I've been in the Palacio Nacional and I've seen the Diego Rivera mural there, and I know who the bad guys are. I recognized one of them, and it was John D. Rockefeller, right? So we don't really have that. John D. Rockefeller exploited Americans as well, but we didn't react by making energy provision a public sector function. We reacted by enacting regulation of the market, and that's I think a fundamental difference in the sort of background or the cultural history of the two countries that makes what's happening now in Mexico seem a little bit strange to American eyes. So those are my primary reactions here. I hope it's two steps forward and one step back, and that we can continue to move forward with this as time goes by.
We certainly do hope that, David, as well. And certainly courts, the judiciary in Mexico is helping, because they are seeing that these reforms seem unconstitutional, and they are granting injunctions. Before entering into like the litigation aspect of it within Mexican jurisdiction, I would like to ask Aldo, what are the international implications of this reform, Aldo? Considering that most probably thermoelectric power plants based on the burning of fuel oil will be favored with this dispatch rules. Mexico could be not complying with their international commitments in terms of the Paris Accord and others. And certainly your area of expertise is the international aspect of energy policy. So why don't you tell us about that?
Well, you already pointed to one factor, right? What this means for international commitments on carbon emissions. So that certainly is a big question. The other one that is already apparent is that this dispute about the future of the rules is making investments or potential investors more hesitant about entering the Mexican market. That means, well, less the long-term commitments to the power sector in Mexico. The other question there is, I mean, as I understand the dispatch rules, it's less about fuel oil and more about having CFE first. Because CFE has legacy investments there that have yet to remain, that have to be profitable. And somewhere in that chain of the order of dispatch is that we see the fuel oil before some of the renewables for reasons that are difficult to understand. Let's bear in mind that the energy system in Mexico, centrally planned and government run, had a tight connection between the national power company and the national oil company. And that the refining sector, part of the way it worked, owing also to legacy issues, for every barrel of fuel, of gasoline it produces 1 barrel of fuel oil. And that fuel oil has to go somewhere. And the usual outlet was the power sector. With all these shifts, we have been asking the national energy system to adapt very fast, to change very fast this reality. And that's where the hiccups are coming, and very serious ones, right? It's maybe some sort of indigestion, if you will, because you have to produce much less fuel to produce much less fuel oil. So then in the effort to clean up the power system, you end up producing less gasoline. That's not a simple equation to equilibrate. And in pointing to the problem, I don't mean to say, well, certainly I don't necessarily have a short-term solution. And I don't mean to say that it justifies everything. It's just to acknowledge that there's a difficult technical and policy challenge to solve. And we do need policies to solve it and that are sustained for the long term. The current confusion in policy, the current regression, if you will, the return policy doesn't help in solving this problem, neither for the power company nor for the oil company, and certainly not for Mexico. We need a way out that allows for clean power generation, cheap power generation, which is what the new model was already pointing at, and also a way to help Pemex. But in a way, and sorry to extend myself, it became a little bit of a perfect storm for the refining system to find itself unable to sell enough fuel oil in the international market owing to its high sulfur content, and not being able also to sell it for CFE. That meant the signal was you have to change your habits and you have to make investments. But for a company that is financially constrained and for an agenda that is also expensive, it's very difficult to solve it right away. So that's part of the complication. And to connect your question, it makes complying with international commitments on emissions, on investment, on maritime rules through IMO and the like, much more difficult. Confusion will not help at all in getting to the new reality and doesn't help competition.
Thank you very much, Aldo. Miriam, would you please elaborate in the possibility of the Mexican state violating its commitments under USMCA or TEMEC, as it's called in Mexico? What are the contents of USMCA that could be at stake here?
Well, basically, the only areas in which the USMCA is not applicable to energy are the so-called strategic areas of the state. In power, this would be transmission, distribution, and planning, basically. But generation is certainly covered. The investment of generation is certainly covered. So from USMCA, there could be derived violations by this law. Although I must underline that the United States and Canada have very little actual investment in generation. What really worries me are treaties with the European Union, especially Spain, Italy, and France, where there could be significant violations, especially with Spain. Spain has done a great deal of investment in power generation, especially renewables. But the supply chain for these types of investment could be very, very much affected, and this could include American suppliers. So indirectly, there could be a violation to the USMCA, as the supply chain could be harmed. Also, I understand President Biden is very much interested in integrating the Paris Agreement into the USMCA. So there could be a lot of political pressure in order to integrate the reduction of sorry, it's not COVID, at least. There could be a lot of political pressure in order to reach other agreements, other politically encroached agreements, if these violations keep going on. Basically, migration, other types of trade might be affected if the Paris Agreement, if Mexico refuses to integrate the Paris Agreement of reductions in investment and other provisions of the Paris Agreement into USMCA. So yes, all hell could break loose, not precisely because of the violation of USMCA, but other bilateral and multilateral international agreements that include these types of investments. And I'm sure Spain is very worried, and we could have state-to-state arbitration in terms of that. There is a lot of concern about international state-to-state arbitration, but we haven't considered that the purchase powers agreements entered into between the independent power producers and CFE have international commercial arbitration provisions, which is also very significant. And we're talking about companies that are big enough and have enough at stake in order to enter into commercial litigation, international arbitration litigation with CFE, not necessarily with the Mexican state, but in as much as CFE is a continuum of the Mexican state, well, the state will be affected because basically CFE is a government instrumentality of Mexico. So there could be very strong international litigation stemmed out of this, in as much as we continue to see that the litigation, that the domestic litigation is not fully resolved. One thing that really catches my attention, I would be closing with this, is that the Congress has not engaged in the constitutional challenge that I was waiting for. The minority, either of the lower chamber or the Senate. I was really waiting for a constitutional challenge, and that would immediately reach the Supreme Court. And if the Supreme Court would have issued an injunction, we would have been much more at peace. Right now, we only have lowest level rulings issuing the injunctions.
Thank you very much, Miriam. I would like to ask David now. First, just giving some context. Just a day before the vote of these amendments at the Mexican lower chamber, the Chamber of Deputies, presidents of US and Mexico had a video conference in which they very likely discussed these amendments. What do you think about what will be the real scope and strength of President Biden's commitment to climate change as a main driver of his foreign policy? Because it seems that at least this time it didn't work. So I assume that both presidents just said, okay, we'll see you in court.
Yeah, so let me first acknowledge the limits of my expertise when it comes to the USMCA. I would defer to other panelists on that, but I can talk a little bit about the fine line that President Biden is walking domestically here on climate versus other values. It looks as though he's taking a strong he's making a strong effort to integrate climate considerations into pretty much every part of the executive branch, including the State Department and foreign policy apparatus. So there are climate experts that are being appointed to positions throughout the executive branch in quite sort of with some sort of ceremoniously in ways that they haven't been in the past, which gives rise to the inference that climate considerations are going to be integrated into all these other government functions, including foreign policy. At the same time, he, as leader of the party, is sort of walking a fine line between the progressive wing of the party, which has made climate a central, strong action, bold action on climate a central plank of their philosophy. And on the other hand, members of Congress, Democrats who have been elected to the House and the Senate from fossil fuel producing states, whose continued ability to win those districts is really essential to the Democrats continuing to control the House of Representatives and the Senate after 2020. And so there's a balancing act that President Biden is going to have to engage in going forward that involves keeping both wings of the party happy and appearing to care about and be responsive to their concerns. I don't know how that's going to unfold in foreign policy. There are Democratic representatives from the states of New Mexico, Nevada, Pennsylvania, who represent oil and gas producing districts. If exports of crude oil and liquefied natural gas become sort of drastically curtailed, I don't know if how that's going to play in their domestic races, but it certainly won't play positively probably. And so these are the kind of considerations that I think are at play as he decides how strongly he's going to stress the climate dimensions of treaties and trade agreements and other foreign policy issues. But I hesitate to predict exactly how that's going to play out. I don't have a crystal ball.
Sure. It's certainly a very complex issue domestically. So I guess bringing the matter to foreign, the subject matter to foreign policy should not be easy as well. I would like to, well, of course, encourage the audience to send your questions via Facebook Live or YouTube, where this panel is streaming. And before going to some of the questions that we have been receiving, I would like to ask Pablo, how do you see, Pablo, the effects of these reforms in terms of the general investment climate or environment in Mexico? It's more like beyond the energy sector. Is there going to be like an affectation to investment in Mexico due to these reforms?
Well, first, in the energy sector, significant projects have absolutely stopped, right? And not only that, but you're typically seeing executive teams of companies with a significant presence in Mexico having to reconfigure themselves from thinking about operations of their assets into defending the value of their assets, into litigation and that kind of thing. So that is incredibly destructive of value. And it's not that investment in the energy sector, private investment in the energy sector has stopped. It's that the value of existing investment is being destroyed because of the policies and the uncertainty that we face in the energy sector. And that's true even when every single policy has been struck down by the courts, right? As you said, even if it's this temporary injunctions, by the way, there have been Supreme Court rulings against the policies of Secretary Nale. We saw that in the reliability agreement that she proposed. It reached the Supreme Court and they ended up taking a strong position there. But beyond that, Jose Maria, I think that it's clear that this is an issue that receives an overwhelming amount of attention, and there's no investor that is sophisticated about its way of doing business that is not at least a little bit knowledgeable about the issue and is seeing the pressure that is coming from the president into the courts and is seeing the way in which the executive branch is trying to exert reputational pressure over companies and really come up with increasingly misleading tactics as to how they position the issue. So unfortunately, folks would have to be very naive if they're looking at this and if they are able to go into their own companies and say, no, Mexico is all about the fundamentals, right? Mexico continues to be this OECD country that gets every single time the benefit of the doubt. Unfortunately, Mexico is changing its profile quite dramatically in a very quick way, in a very destructive way. So I definitely think there's ramifications throughout the economy. And this is particularly disappointing in the context of the new USMCA, in the context of the recovery that we need from COVID-19, and extremely disappointing in what should be a golden time for Mexico in terms of investment. All the nearshoring, all the different engines for growth that Mexico had at our disposal, we're just throwing a wrench in there and making sure that we are not able to fully tap those things that the country has going for itself and would be otherwise incredibly powerful engines for growth.
Thank you, Pablo. We have a question from Professor Alejandro Ibarra from the Tec de Monterrey and also from UT. And it's a question for Aldo specifically. How do you think, Aldo, that these amendments will affect local marginal prices in the wholesale electricity market and eventually the basic supply tariffs? And also, what do you foresee for on-site generation projects? Are they going to be affected as well, or we are going to see like the continuing flourishing of these kind of projects?
Well, we already expect with a shift in the order of the dispatch, higher costs of generation. If we move from low-cost renewables to high-cost fuel oil, for example, whether that is reflected in the electricity bill that households face, it depends on what's going to be the final decision with respect to CFE's pricing, right? And who's going to bear the cost, whether the company, the government, or the consumer. So that will have an impact somewhere. With respect to I'm not sure I understood the second question, but let me connect with what has been said already. Investments are already being affected. The prospects for private investment, whether it's through distributed projects or not, is not clear now because the rules are not clear. Everything right now is kind of up for grabs until we figure out what happens, how the Supreme Court ends up interpreting these rulings. We've already heard many times that as it stands, they are not constitutional, these proposals. We have yet to see what happens with the upcoming federal election and what will it mean. So meanwhile, we will have a period of uncertainty, an aura of confusion that will affect the pace of investment.
Thank you, Aldo. I would like to ask Miriam, if you could explain the audience, Miriam, what has happened in terms of injunctions at federal courts, and what do you think about the general effects of such injunctions, which I know you have doubts about that in terms of their constitutionality, but the point is that the law at this point, or the amendments, are suspended.
Mm-hmm. Well, you really put me in a hard spot there, because we've been debating about the general effects of this injunctions for weeks now. Chema, José Roldan, and I am the dissenter of the enthusiasm of the general effects of these injunctions. I think that the lowest, a judge that is part of the lowest hierarchy in the federal judiciary should not leave a law of Congress without effect in general terms. I still believe that the amparo should protect who has filed for constitutional protection. I see that the companies argued, like NGOs, which is really interesting because they argued in favor of the public interest, meaning competition, antitrust arguments, environmental arguments, and right to a healthy environment arguments. And those arguments have been used by the NGOs claiming a legitimate standing in the litigation, not necessarily a legal standing. I mean, whereas the NGOs do not have a legal standing, they have a legitimate standing because society is affected by these laws. So the companies replicated this formula, and they have been successful so far. And I, as a member of society, I'm uncomfortable with companies arguing for my interests. Obviously, I am not uncomfortable with them arguing for their interests, and actually I'm an attorney of companies. And I am very happy for the companies, but I'm not very happy about the implications, because I think that there are limitations in the rule of law. And we cannot have markets in a country where the lowest hierarchy judge decides to disappear a law of Congress. I think it's too dangerous. And I think I'm going to be getting a lot of criticism out of this, but we cannot be choosy with the rule of law. I don't like this law, so I'm happy with a judge, with a lowest level judge, vanishing this law out of the face of the Mexican legal system. But what happens if I like this law? Will I be happy if the lowest level judge disappears from the Mexican legal system? So in terms of the matter, I am very happy. Senate published the suspended injunction yesterday in the Federal Official Gazette, saying that the law for now is that the effects of the law are suspended until the trials finalize. And I'm going to say something that's even more uncomfortable. I'd like the Supreme Court to review this case. And people are going to say, no, don't say that. There are 4 justices that are committed to the president. Well, that's exactly the same argument as saying that this judge is committed to the companies. if you're going to argue a conflict of interest, you have to prove it. And if we're scandalized, if the president is scandalized about the alleged lack of independence of the judges who ruled in favor of the companies, are we going to be scandalized about the lack of independence of the justices who might not actually rule in favor of the companies? I think it's a very delicate issue. And I think I'm pretty much alone in arguing this. But when it comes to the rule of law, I like the rule of law. I like the rule of law when it comes to laws I like, and I like the rule of law when it comes to legislation I don't like. Because legal certainty and the rule of law is the basis for healthy markets. So I would like the Supreme Court to say this law is unconstitutional, because there would be no doubt left that this law is unconstitutional. There would be no other way out. And as we have to trust these judges and their criteria, these lower level judges and their criteria, we have to trust the justices of the Supreme Court as well. We cannot be picky and choosy, and we cannot be selective when it comes to justice. We have to have an even criteria.
If I may jump in just very quickly, I think it's inevitable that it will reach the Supreme Court, perhaps not from a process standpoint, but I think that given the opinions that we have seen from Supreme Court President Saldívar, who is essentially saying, I would like for this case to reach the Supreme Court, and other justices that have been very vocal, including Justice Yasmin Esquivel. She's been very vocal about this issue. So I think we are seeing
justices. You need 8 justices, and there's going to be a lot of political negotiation within the court.
Yeah, but my point is,
traction, you have to have 8 justices bring it to the Supreme Court. So I think it's very probable, but I cannot say I'm sure. When it comes to the law, you can never say I am sure, because the law is not a science. Your best guess and your best criteria. Hopefully.
I couldn't hear the full argument because it might be my Wi-Fi, but my point is, it seems that justices are signaling their interest of trying themselves this case, and whenever you have that interest, given the faculties that they have to attract it, I think it's going to be inevitable. So it should be good news for you, because you want this to reach the Supreme Court. And I'm saying it seems that it's bound to reach the Supreme Court. So we should be having celebration about that, because based on your argument,
they will be celebrating because they want to be the trials done and over sure, and I think I want their contracts, and they want their contracts to be safe. I want the industry to be safe. And in order for the Supreme Court to, I don't know if my translation is precise, to attract this case, to draw this case, you need 8 votes out of the 11. And there's going to be a great deal of negotiation in the court. There are some justices that don't want to touch this with a 10-foot pole, because their careers would be heavily compromised. So I hope it reaches the court. I hope the court is fair. But as I was saying, which I think that your Wi-Fi failed, is that you cannot have certainty about the judiciary, because after being a lawyer for 25 years, you have best guesses, you have nuances, you can infer, and then everything turns out the other way around. I mean, unfortunately,
Miriam.
It's not a social science. Mm-hmm.
Thank you, Miriam. It's a very interesting debate, and we could keep talking about this particular issue for a longer time. But I would like to move forward with a question for David, and it comes from Antonio Noyola. Antonio is a member of the Mexican Traders as Energy Traders Association. And he's also a Longhorn, by the way. So he's asking, one of the main challenges is reinforcing the grid and improving technical interconnections, norms and standards to allow additional intermittent sources. However, all the players, including intermittent generators and consumers, lobby against tightening standards. The question for David is, how was this issue resolved in ERCOT and other US markets? With ancillary services, perhaps? Is that the answer? Is that the solution, or it's broken?
Well, as you probably know, Texas has an awful lot of wind generation and a lot of wind potential. And as it was beginning to grow and really rapidly, say a decade ago, 5 to 10 years ago, there were a lot of claims by grid operators that we can't integrate all this wind and keep the lights on because it's a variable resource and it's just too difficult it destabilizes the grid. And what we found was with some tweaks in the way we schedule plants, the way we manage ancillary services, the units of time over which we make dispatch decisions, when we sort of changed those rules, we were able to integrate lots more wind, such that both in Texas and in the upper Midwest, we often get periods when wind power comprises more than half of the generation on the system and the lights remain on. And so some of this had to do with forecasting, weather forecasting, and improving the capability there and matching that up with the sort of day ahead market planning and ancillary services planning. All of that turned out to be sort of as we would say here, a cry wolf problem. The grid operators claimed that it would be impossible, but it turned out that they were able to do it. And grid engineers are problem solvers, right? You give them a challenge, they often 9 times out of 10 will find a way to meet it and to solve it. And so I think the hesitancy or the reticence about that is probably misplaced, at least until wind grows to be 60, 70, 80% of the generation. Then you start to run into these more difficult technical challenges.
Thank you, David. Certainly, technical challenges are there and need to be solved with creativity. I would like to ask all of you, fellow panelists, like a final word. And I would like to base my question in a question that we have here from the audience. It's not clear who asked it, but they are saying, if you went back in time to 2012 or 13 and meet President Peña Nieto, what would you tell him not to do in terms of the energy reform for preventing this reversal, sort of reversal? It's not a full reversal, I would say, sort of reversal that we are living now. And if with this you want to give a final word about suggestions, recommendations as to what to do to solve our issues in the Mexican electricity market, I will totally appreciate it. So let's start this time with Pablo.
Sure. So that's a difficult question to answer. I think, Jose Maria, that some folks interpret the energy reform as being, the results of the energy reform as being tied to this push from President López Obrador to reverse some part of the energy reform, right? And if you follow that analysis, well, then you reach conclusions like you should have communicated better. You shouldn't have promised that prices would decrease. You should have made an effort to engage the broader public. And you should have really done a much better political job at selling the energy reform and making it sustainable over time. I disagree with that view. I think that regardless of the communications effort that the Peña Nieto administration could have taken, President López Obrador was predisposed to think that any kind of opening was sacrilege, and if he reached office, he would have pushed against it. I think that you certainly, at this point in age, at this point in time, you cannot make an inference about saying, well, the energy reform is unpopular. No, I think that it's one of the, I mean, if you look at the renewables industry, it's one of the few industries in the country that have very diverse support from different parts of the public, right? And the politics around it are completely untied to public opinion, and they're completely untied to whatever the public thinks of the energy reform. This has everything to do with President López Obrador's mindset, and very little to do with the results of the prior reform. It has very little to do with how things have really played out. So in a way, how do you make the energy reform not be reversed? I mean, he could have done a better political job and not have his party lose in a landslide. No?
Chema, can I say something really quick?
Thank you, Pablo. Go ahead, Miriam.
30 seconds.
Actually, just to clarify, this question was asked by Ana Lilia Moreno from the think tank Mexico Evalúa.
Ana Lilia, our buddy, Chema. Well, I do have a very concrete suggestion, which I made, I think, from day one, when I saw the secondary legislation, is that it was too centralized on the executive. And I wrote about it. I spoke to Undersecretary Melgar about this. I spoke to Undersecretary Chavez Hernandez Ochoa about this, and they said it was fine. And it's the weight of the implementation of the reform is too centralized on the executive. And what the executive can do, the executive can do. And now we have the worst of both worlds. We have the executive in the hands of a man who hates the reform, and we have Congress and the man in the hands of a Congress that hates the energy reform. So it's the worst of both worlds. If we had some form of checks and balances, Congress would lessen the weight of the executive. But here came a president who has enormous political power, and I adored Pablo's analogy with Willie Coyote, because I love Willie Coyote because he's an underdog, and López Obrador is an underdog, and he represents the underdogs. So thus his enormous political popularity. And now the main decisions of this reform, which is not a reform for underdogs, is in the hands of Willie Coyote and of Secretary Ainsley. It's way too centralized, and that could have been resolved from the outset in the Constitution and the secondary laws. And I think it's a shame.
And thank you, Miriam. Now, finally, Aldo and David, it may be harder for you to answer this question, Aldo, because you were part of the past administration, and David, because you are not Mexican, but please go ahead with any thought will be valuable to close.
I'll connect with part of what has been said. One, I'll use the C's, communicate better the reform. Would have, to use my other C so far that I've been using a number in my interventions, would have cleared a lot of confusion, and expectations would have been much more tamed at the outset. The second part is compensate. The mechanisms for compensating consumers or losers in the oil and gas industry, but also thinking about the process of phasing in potential losers into the new reality in the power sector would have helped. And the third one that is sometimes forgotten, which is coalesce better, or the coalitions that were made in Congress, in the Mexican Congress, to pass this legislation. Let's remember that the initial position of the government was a little bit more moderate, that it was the way the coalitions were formed in Congress. It ended up being a center-right coalition as opposed to a broader coalition or a center-left coalition that made the energy reform happen. And the fact that the left did not fully participate in the final design meant that that ownership was not as broad of this reform, and created conditions for what Miriam has observed, and and Pablo, of a president that is already bent on saying something quite different. So communicate, compensate, coalesce better, create better coalitions for next time around.
Interesting. 3 C's.
Three C's.
The 3 Ds are popular now in energy. You talk about 3 C's. Please go ahead, David.
Yeah, very quickly, what Pablo said about the mindset of the president really resonates with me. And I wonder, you can think of a change that invites capital into the country to invest in renewables. You can frame that as both nationalist and sort of populist, in the sense that it brings benefits to all the people. It's popular. I don't know whether that kind of framing would have ever been possible in a way that the president could have accepted. I defer to the rest of the panelists on that. But if you believe that that sort of logic wins out in the end, then perhaps just sort of staying the course in courts and in the court, and also bringing the message to the people that there are big benefits to be had here. Maybe in the long run, that's the long game you want to play. I don't know.
Thank you, everyone. And I will give the word to Ricardo Ainsley now, thanking everyone, of course, again.
Thank you, Jose, Maria. Terrific panel. I want to thank all of you. Very interesting, very, no pun intended, energizing to hear the points of view that you all shared with us. Jose Maria Lujambio, our moderator, did an excellent job of shaping the questions that our panelists shared their views on. I want to thank Miriam Grunstein, Aldo Flores, David Spence, and Pablo Sarate. You all were really great. And on behalf of the Mexico Center, it's just an honor to have a panel of this caliber. So thank you. I also want to thank Paloma Diaz and Mariela Garcia, who did the magic behind the scenes at multiple levels, and without whom we really wouldn't have been able to do this. So thank you all. Thank you, our audience. And I'm sure the conversation will continue unfolding. Goodbye.